All right, we're going to talk about some of this testimony. Ross Kramer, criminal defense attorney, here with me today. Thank you for joining us for your expert legal analysis. Tell us about the fact that this witness, as a forensic evidence technician, is telling us every little thing she did with each swab that she took, latent print that she lifted. Why is that so important in a criminal case?
Well, because it has to be done perfectly, all of this. The evidence has to be preserved in a certain way. It's called chain of custody. It has to be handled in a certain way. It has to be tagged. Because as in a case like this, it could be years before something goes to trial. And a defense attorney can pick holes in whether, a piece of evidence disappeared for a couple of years in the back of a storeroom, or whether anybody was taking care of it, or whether it started to break down over time, how it was tested, when it was tested. It's very important.
So tell me this, what are the legal ramifications? Let's say that defense was able to prove that she can't explain what she did with something after she took a sample. What does that do legally? Does that evidence get thrown out if that were to happen?
Well, it could get excluded completely, or just as helpful for the defense in many cases, it could inject a lot of doubt as to whether any findings were actually accurate. If a sample that you tested in 2017, you can't actually prove where that sample was for 5 years and whether it was actually the one that was taken 10 years before. That puts a lot of reasonable doubt into a case.
In cases that you've tried, how do you make this kind of testimony interesting to the jury and the judge? Because the fact of the matter is it's tedious, but you have to do all those pieces to get this evidence credible and admissible.
Yeah, I think you do two things. One, you try to make the lead up as short as possible. You have an obligation to get in exactly what happened with that evidence and how it was maintained. But you try to get to the conclusion as quickly as possible. And I think you also, in your opening statement, try to give the jury a sense of the fact and give them a preview that there's going to be a lot of science leading up to it, but it'll pay off in the end. So pay attention, take notes on it, and at the end you'll see where we're going.
And I know we talked on a break. I like her testimony, so we're going to stay tuned. I think that she sounds very credible, and she's outlining everything she did. We're going to take a short break, but then we'll return to the McStay family murder trial. All right, again, Ms. Williams is the forensic evidence technician. And Ross, you and I were talking on a break, and I want to talk to the viewers about this. Why is the prosecution compelled to go through and literally tell the jury every single item that was found in a car?
Okay. The prosecution is not compelled to do that. The prosecution feels compelled to do that because prosecutors generally want to go above and beyond and cover all their bases, and they don't want to risk the other side or the defense claiming that something important was overlooked here. But this is a good example of why this case is going to take 5 times as long as another set of prosecutors may take on this case. I don't understand the value of going through everything here, but they want to cover their bases. The judge is always going to let them do it, and they're going to do it. The risk is losing the jury and losing the jury's attention. I know we can't see it on TV, but there may be jurors there that are doodling on their pages or completely falling asleep here, and that's the risk that prosecutors run when they go through evidence to exhaustion.
Okay, but let's play devil's advocate. Does it not give the defense even more room to argue a valid defense? Because they can say, listen, who cares? None of this is relevant. There's no evidence there in that car in and of itself that proves that this defendant actually committed these crimes.
Well, I think we have to wait a couple witnesses later, and we had talked about this off air. The issue is whether any of this other material found in the car is relevant, and it may be. And the judge will give a prosecutor leeway to show later on in a case how it's relevant. So we don't know. Maybe there's some DNA in the back seat of the car. Maybe there's some significance to the business cards or the checks that they found. And the prosecutor doesn't have to firm all that up through this technician. They could just bring the evidence that was found in the car in through the technician, and then later witnesses can talk about what the significance of that evidence is.
And I know that we also were talking on break with Kathy Russin. We're going to go back to that after break because we have a few more questions about that. But stay tuned as we continue to cover multiple trials here on Law and Crime. All right, that was defense's closing argument in the Monell case. And so I want to bring back in Ross Kramer, our guest today, to talk about what do you do as a defense attorney? Listen, we know the evidence in this case is that his defendant's bloody handprint was on the knife used to stab the estranged wife. The estranged wife had 48 stab wounds. There was a 12-year-old eyewitness that says this defendant, his father, the husband, did it. What do you get up there and argue at closing?
Well, I can tell you what you don't do, and you don't do whatever we just saw, because that was rough to watch. That was somebody waving the white flag. His body language, his energy, the sort of rambling arguments he was making, started telling stories from his own life. This was completely directionless, completely passionless, and I can't see a jury taking anything useful out of that. I think what you do is you pick the one or two or three small things in the case that you think you got a point on, even if it's not proving your client is innocent, but something that the prosecution got wrong, something the investigator got wrong, and you shove it down a jury's throat over and over and saying, if they got this wrong, what else did they get wrong? You have the highest burden of proof in a criminal case, which is proof beyond a reasonable doubt. You harp on that and tell a jury how high a burden that is. You tell a jury that everyone is presumed innocent and that they have to find them guilty based on real evidence in the case. And you act like you're there defending your client and defending his rights and defending justice. This lawyer looked like he stood up and he was defeated from the moment he started talking, and I think that's a very bad message to send to a jury.
And so conversely, I've seen trials, Ross, where the prosecution, frankly, at the end of the case, I think realizes, whoops, I don't think our evidence was as strong as we might have thought it was when we charged this particular defendant, but they still argue zealously and with passion. And so especially given the fact there's a jury watching this, how important is just the energy level? Even if you don't say all the right things, don't you have to stand and act like you believe in the case, you believe in your client?
Yes, so I think that that's very important. I think you are a representative for your client. You're the voice of your client as a criminal defense attorney, especially where your client's not going to testify. You are speaking for them, and the way you present yourself is the way that you want a jury to see your client. But I think that what wins cases are really the facts and the narrative. This lawyer stood up without even a pad in front of him, without any notes, and apparently without any bullet points that he felt were his best shots here. It was sort of a stream of consciousness closing, and I don't think in a case where you're already behind that that's the tactic that's going to win a case.
All right, so strategically, would a defense attorney ever not do a closing in a criminal trial in your experience?
I don't think so. I think at least to get up and say, look, I don't have to prove anything to you. I have no burden here. This is completely on the prosecution to prove this case to you and go through how difficult it is under the American system to get a conviction that has to be unanimous among all the jurors. Even if you don't have substance, say something.
So we are going to stay tuned. We are covering a lot of very interesting trials you're not going to want to miss. We're going to take a short break and come right back to Law and Crime. All right, so that's the prosecution's closing arguments in the Monell case. The defense went first. We covered that. We talked about that some. Now I want to talk with Ross Kramer, again, our criminal defense attorney, about prosecution's closing. There were a couple of things you and I noted and started talking about as we were listening. One of them is, I think it's unfortunate. I feel like he's choosing some words to indicate that, oh, nothing happened to have provoked this. Well, who cares? It's still murder even if provoked, right? Or am I misreading that?
Yeah, listen, I think, so I don't like this closing either. I think that he's taking the wrong approach here. As the prosecution with the burden of proof, he should be focusing on the evidence he showed the jury, affirmatively. I showed you A, B, C, D. When you put these together, there's no way there could be reasonable doubt. I've covered all my bases. Instead, at the beginning of his opening, he's focusing on the arguments that the defense set up and trying to knock them down. That's not where he should be here. He should be proving this case to the jury and bringing all his evidence together, because that's the purpose of his closing.
All right, so it is going to be interesting to see what the rest of the closing argument is like. We hope to return to that. We are covering 4 different trials today. I know it's juggling, but there's a lot to cover, a lot of interesting cases that you will not want to miss. We are going to take a break. We're covering some on LawandCrime.com. Come right back. So again, this is the Monell case, and this is one in which the father and husband allegedly stabbed to death the estranged wife. Now, this is the prosecution's closing argument, and I know here on Law and Crime, it's easy to sit in this chair Monday night quarterback. That can be an easy task, but let's talk, Ross, about the reality. This prosecutor seems to be, in his closing argument, walking through every single point for the jury versus maybe a theory of the case with a compelling argument as to why this person's guilty beyond a reasonable doubt? What do you think?
I think it feels like he's sleepwalking through this closing, that he doesn't have, he's not projecting the strength that his case has. I mean, they have a wealth of evidence here. It feels like, this is a case where they're going to get a conviction, and he should stand up there with that body language and with that idea. He should say, look what you heard. You heard 1, 2, 3, 4. This is evidence that's uncontroverted. This is enough for you to convict. And on top of that, you have this, you have this, and this. Short, punchy points. Get himself up. I know viewers saw the closing arguments in the cop trial that we're about to go to the verdict for. I thought that lawyer was a little over the top on behalf of his client, not because of the way he acted, but because it was a bench trial where he was performing for a judge. But here you're performing for a jury. The jury has expectations. If you have a strong case, act like it. Don't be leaning against the rail on the side like you're bored to be there and rattling through things that you're not excited about. Pick your strongest points, get the jury excited about it, and lead them to the conclusion you want them to find.
Sure, but let's be honest. Does a jury really listen to what they're saying in closing argument? Or are they so done with having to hear all the evidence, they're ready to go back and deliberate while it's fresh in their mind? Do they really pay attention, do you think, to either side's closing argument?
I think if it's done right, they do, because the point of a closing argument is that it ties together all of the evidence that was heard in a case. And when you watch TV trials, it looks like the evidence all comes in very logically and sequentially, and it tells a story in itself. In reality, that's not the way it works. Evidence comes in scattered. It comes in through different witnesses and bits and pieces. And a jury could be sitting there saying, I'm just not sure how this all fits together. And then the job of a lawyer at the end is to tie all those pieces together and put them into a cohesive narrative.
And in this case, I can't help it. If we think about the why in this case, I just want to say one more thing for the sake of the viewers, and that is we know from the evidence presented that they actually had a restraining order, this wife did, against him, that there was a history of years of abuse. And so when you get to the why, you can use that evidence and argue, listen, this man was not happy with this woman and had been rejected. She had a restraining order, had been violent for years. I just would hope that that comes out in closing argument, but we're going to have to wait and see. So we are covering 4 different trials live here on Law and Crime. I will recap those after we come back from a short break. Please join us when we're on the other side of the break. All right, we are still listening to the judge reading her verdict in the cover-up trial in Chicago. And again, Ross, so she is still going through the indictment. It was very lengthy, filed by the state, and it says all of the things that they're alleging that they must prove. What are your thoughts at this point? We've been into this now for, I don't know, at least 8 minutes.
This is not the way that I would have done it as an attorney. This is not the way I would like to be sitting in the courtroom and listening to. You have people there that are hanging for their lives here. They're sitting there. Their personal and professional lives will never be the same, if this is a verdict, if this is a conviction against them. The lawyers spent all this time working on it. The public is hanging on every word here. I would either go with your verdict or your finding of facts and actually get into the meat of this. I don't think that anybody sitting there needs to hear what the allegations were again or what the elements of each offense were. I certainly wouldn't start out with that, and I don't think you need to read it publicly. You're going to file this document publicly later. If you want to include that, you can include it, but I don't see the point of bringing these people in, having them sit there through the most stressful moments of their lives and having her read legalese to them.
And so I think what we can expect, right, is that she is still going to have to make finding of fact, whether she says it out loud or has it in a written order. But she already indicated, I'm going to read my entire order. So we should be able to expect findings of fact by the judge and then the conclusions of law. And the conclusions of law will include the verdicts. Is that what you would think?
I mean, it's possible. A judge could structure this however she wants. She could read the allegations. Then she could say in one sentence, my verdict in this case is whatever. It's based on the following findings of fact. Or she could say the next section is the findings of fact and wait for her verdict to the end. Until we hear it, I don't think we can be confident as to how she structured this.
So let's talk about, you can see some of the attorneys, and I've seen some moving their legs and seeming very restless and uncomfortable and putting their head in their hand. How does it feel as a defense attorney when you're seated next to your client, the defendant, who literally is waiting for a decision that affects the rest of their life?
Unbelievably stressful. As an attorney, as someone on trial. I mean, these are the most stressful moments you can be present for. You know, in a case like this, I have a feeling that even if they're convicted, they're going to walk home today. They're not going to be held until sentencing. But you said it's sentencing with a client, and they're about to be sentenced, and more likely than not, they're going to be put in handcuffs and taken away from their family. Could be in the back watching this. I'm sure these people's families are there watching the verdict today. I mean, this is as stressful as it gets on behalf of both the clients and the attorneys.
All right, so let's return to court and see what the judge is saying at this time. Wow, this judge has said a lot. She is looking at the totality of the evidence. She is going through each piece of evidence. Ross, what do you think so far? Guilty, not guilty?
I mean, it sure sounds like it's not guilty here. I mean, she said a lot of times this doesn't rise to the level of beyond a reasonable doubt. It doesn't meet the standard. I think she is trying to give a number of reasons for why she thinks that the witness testimony she heard doesn't match up with the elements of the statute. I thought maybe the most interesting thing she was saying was that Laquan McDonald, who was the victim in the case, who was shot by Van Dyke, could have appeared to police officers on the scene as an imminent threat, threat to public safety of the officers, of civilians. I mean, it appears that some of her decision was in direct contradiction with the jury verdict in the Van Dyke case.
Yeah, I agree with you, Ross. At the beginning of her order, that's what she started to recite and all the different pieces. And he did have a knife. He did refuse to drop it. He did stab a tire. So we're going to stay tuned. We're going to go back in and listen to more of her findings. Wow, so there you have it. This is breaking news. Her final line after reading a very, very well thought out, thorough order that she has drafted, the verdict, not guilty on all counts for each of these three defendants. Ross, are you surprised or not?
I'm surprised. I'm surprised that at least that she went as far as she did in her verdict. I really think she went further towards the substance of the Van Dyke case and what officers were perceiving there than she had to, and much further than I thought she was going to. I think that the Van Dyke attorneys will probably use this verdict to support their appeal.
Yeah, it was interesting she did that. So let's talk about, there are 4 different areas she really included in her findings of fact. She talked about, number 1, the different police reports. Number 2, the videos that were discussed, and she pointed out these videos did not necessarily capture the perspective of these 3 defendants. She talked about the victim's actions, and that's where, let's start with that, because you've just mentioned that. She really did go in depth with all of his behaviors and what he did with the knife, how he was acting, where he was walking. Are those the specific findings you think might be useful if Van Dyke and when Van Dyke appeals?
Yeah, and I think she said at a certain point, I mean, we don't have this in writing right now, but I think she said that his actions could have reasonably been perceived by an officer on the scene as aggressive, as putting them in danger, as potentially putting other citizens in danger. I think that's in direct contradiction with what the jury found in the Van Dyke trial.
All right. And the 4th thing that she talked about were emails. And she said, look, that's speculation at best as to a conspiracy. And so she went through each of those 4 different types of evidence, the testimony that was presented, the documents that she reviewed, and why each of those 4 things, the state, in her opinion and her verdict that she's issued, did not prove beyond a reasonable doubt. So this is breaking news. Now, Ross, you and I were talking about the fact that the prosecution even brought these charges against these police officers is progress in terms of the state believed, obviously, they could prove these charges, conspiracy and unbecoming conduct, and that's why they pursued it. But this is new, it's unusual and unique that they pursue these kinds of charges.
You know, a lot of times there's social value to trials, to the holistic value of trials, no matter how they turn out. This was an airing of public grievances against police officers for a public act that they took. There were other police officers that testified on behalf of the state, and I think anyone should hope that this opens up an era of being able to bring these cases, whatever the verdict, when there are legitimate concerns about police officer conduct.
I completely agree with you. So it is going to be something to get the actual order once it's been filed in so that it's public record. We'll be able to look at that and really digest, because there were a lot of findings of fact facts, conclusions of law that, as a trial nerd, I can't wait to get my hands on to read it all over again. But here you've heard it, breaking news live, first on Law and Crime. Again, the 3 police officers charged with a cover-up conspiracy in Chicago and the Van Dyke shooting of Laquan McDonald, not guilty on all counts. They all will walk free, no convictions. We're going to take a short break, and please rejoin us right after this break.